Fast forward, you come over channel, so I'll say Gage Politics Avenue. Podcast or training because make headlines. Ne jembre ne bi Excerpts ewo ha ne dem ne ho braxi mu onua yanko yensimu yeko yensimu eye tamaklo na me no kasa wotimi asusuja edi agu eye remove justice Gertrude Torkonoo echima onua enya aksem koto akra na nyina said asem awo kanyina no na it boils on to tama ni issue ni bae no na ede wo so wo ye ne se enkentem na kapa maame no etimi ede eye the resignation letter fast said the beya obetimi I am joining retirement what package but maame no etimi engage in constitutional lawlessness and the amount retirement package na etimi abona wajemre na osusuje edigu na pampama onu enya asem koto akra be sure say yenkum wanse ni mune hwe ne yeko ene de eba AGH Politics Avenue.
Thank you so much for coming. Earlier, yesterday we got information of the former Chief Justice Gertrude ļǎwǐessněss Torkonoo filing yet another application at the High Court, essentially a judicial review. In fact, this is the 8th application since the entire process of her removal began. But let's recall her position about this entire removal process right from the get-go. And this application goes to buttress the points that she made at the press conference that she addressed during the process of her removal, essentially regurgitating some of the issues. But she raises a number of questions about the entire process of her removal in this latest application, questioning the locus and the decision of this committee that was established and the basis for her removal, essentially. This is the former Chief Justice during that press conference earlier. Take a look.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
That's the former Chief Justice Gertrude ļǎwǐessněss Torkonoo there. And as I indicated, this is the 8th and the count of the number of applications since the entire process began. First, from the 21st of May, that writ of summons at the Supreme Court, which is actually yet to be determined. There are a number of the applications that are still active and yet to be determined. The 21st of May, the two, one is yet to be determined. We'll put that on the screen. The other was unanimously dismissed as the case progressed. We also had that one on the 9th of June, 2025. This judicial review at the High Court. In fact, this follows in the same fashion of what we have now. We're going to put this on the screen right now. It also follows on the path of this judicial review, this latest application as we have it. There's also the July 4, 2025. This is a case that is still active. In fact, at the ECOWAS Community Court, this is a case that is yet to be finalized. It's still an active application. We saw another judicial review that sought the reliefs against the Shining Stars of Ghana, essentially questioning the legality or the legal existence of these Shining Stars. one of 3 petitioners against her, and then this latest one that we are seeing now. And these are some of the grounds that she is grounding her argument on. That the first finding against her about the misappropriation of the said funds is false, misleading, irrational, and illegal, because it cites misconduct for expenditure that was neither disallowed nor surcharged by the Auditor General, to the extent that the Auditor General did not raise queries about this. In her view, it's irrational and illegal for you to even use that as a basis for her removal. Also, that this same first finding of misappropriation is also unreasonable and unfair because it attributes unauthorized expenditure to the Chief Justice, though she neither authorized nor administered it. This is not a spending officer. The second finding is an abuse of power and unconstitutional as it wrongly treats the Chief Justice's lawful administrative duty, and this has to do with the transfer of judges. Under Article 1254, including the transfer of judges and officers as misconduct. He says, the third finding is an abuse of power and unconstitutional as it mischaracterizes the Chief Justice's legitimate role under Article 1254 and established conventions in judicial administration as misconduct. And in fact, it says it's also unlawful, challenges the Chief Justice's conventional role shared with the Ghana Bar Association Attorney General in recommending the promotion of judges. This is the position of the former Chief Justice and what she is seeking in this particular relief, the latest. I start this path with Godwin Eduji Tamaklo because this is not the first time we're having to lay a matter of a judicial review by the former Chief Justice. There are some who hold the view that this continuous application is an abuse of the court process. Others are of the view that, look, to the extent that this is unprecedented, all these applications must be allowed so as to tick all the boxes, bring clarity, form a strong precedence so that we'll see how the days and years ahead will look like. Before you answer that, let me acknowledge Bracco Powers is a private legal practitioner as well joining us. So Powers, good morning. Thank you for joining us.
Good morning. Okay.
Perfect.
Okay. I'm not surprised that now removed Chief Justice Gertrude Araba Saki Torkonoo had decided to file this judicial review application. I'm not surprised at all.
Why doesn't it surprise you?
The reason is simple. You see, Alfred, as young as I am, there are certain things that when you are advised and you decide to do otherwise, it goes against you. Look, in the midst of these petitions, two prominent Ghanaians said, look, if the Chief Justice wants to resign, she should be permitted to resign. I recall vividly, the argument was made. The Constitution says, and the Supreme Court has clarified the issue, that once an Article 146 process has commenced, you do not have the option of resigning. At that time, there was a strong push that, hey, Justice Torkonoo had worked High Court, Court of Appeal to Supreme Court. And therefore, that matter, for her service to this republic, she should be permitted to resign and take her emolument. So she can go. At least when she resigns, she is entitled to her benefits. Just when they were waiting for that, from nowhere, she decided to do a judicial process, somersault. I think today, she's come to the realization that she ought to have resigned instead of allowing the process to go through.
You said that was not on the table.
Please, I know, and for this privileged information, I cannot even name the people.
Amaliba also came and said it.
Look, two prominent people.
And we supported it here. Remember, you and
I was opposed to it. You said, look,
yes.
It should be allowed, even though the Supreme Court, because what had happened was that there was a High Court judge who Article 146 process had started against him. Yeah. Then President Mills was in the process of putting the committee together. The CJ then, Georgina Wood, started the process. Then the judge, knowing that if that Article 146 committee concludes its work, he stands the risk of losing his entitlement, quickly tendered in his resignation. So the question was whether President Mills was bound to accept the resignation. And the Supreme Court interpreted the matter and said, once an Article 146 process had commenced, there is no option. If not, you defeat the very purpose of Article 146. But you see, we are back to this point because her ladyship, the Chief Justice, now removed. Options are completely gone. Completely gone. The options are gone. Let's look at the legal issues now. I've gone through the judicial review processes and the attachment. I spent yesterday reading through it. Now, if you look at the grounds of the judicial review, and if you look at the things and the reliefs that she is seeking, you come to one irresistible conclusion. An appeal of the Puaman-led committee and its work disguised as a judicial review.
It's appealing.
It's an appeal, but disguised as a judicial review application. But you see, as lawyers, we have the skill set to uncover and to unwrap these wraps that she had put on the processes. Because essentially what she's saying is that the Puaman-led committee had done its work, but I disagree with their findings and the conclusions reached and their recommendations. And for that matter, I want a high court to have a second bite. That is not allowed by law.
After she has been removed.
Yes. That is not allowed by law. And the reason is simple. In the wisdom of the framers of the 1992 Constitution, they didn't want an Article 146 proceedings to be appealable. And so when they were creating the Constitution, what they did was that when it's a commission of inquiry, under Article 284, you are permitted to appeal. So it says that a person dissatisfied with the findings of a commission of inquiry, like Brazil, Ghana at 50 or this, you have the right of appeal. So finality is not in the work of that committee. It can be judicially reviewed or through a high court intervention. So in this case, what you do is that you allow the high court, when it comes to a commission of inquiry, but here you go to the court of appeal. And that is why for lawyers we say an appeal is a creature of statute.
Right.
There must be a statute that creates that right. Now when she looked at the option, she realized that no, there is no right of appeal envisaged under Article 146. So by legal ingenuity, try to come out with a judicial review, but to achieve the same end of an appeal. Because in an appeal, we say appeal is by way of rehearing. And so if you look at her relief, what she is seeking is to have a high court judge now sit and say, okay, the Puaman-led committee, you have done your work, but to my mind as a judge, you were not fair to Torkonoo. Basically, to have that high court judge now sit in judgment over the Puaman-led committee, that is unconstitutional. That is constitutional lawlessness. Complete constitutional lawlessness.
You describe this as
Complete constitutional lawlessness and should not be entertained.
So she's accepting
Let me
right.
no, let me tell you. If you look at grounds 1 and 2, reliefs 1, 2, 3, and 4, what she's doing is to say that the committee says I'm not fit and proper by reason of the findings of stated misbehavior. Right? However, to my mind, I am fit and proper to hold the office of Chief Justice. What you must understand is that under our Constitution, there is only one set of group or a group of people who can make that determination. Not even the Supreme Court. It is only the committee set up under Article 146. And so, in the year 1994, the Ghana Bar Association decided to test that fitness question in the Supreme Court in what is known as the Urban case. The Ghana Bar Association versus the Attorney General, popularly called the Urban case. What was it about? President John Rawlings had then made Urban the Chief Justice. The Ghana Bar Association quickly issued a writ at the Supreme Court. In that writ, all they were seeking to say is that Justice Urban does not meet the constitutional threshold of becoming a Chief Justice. What they wanted to do through the back door is to trigger Article 146 proceedings by using a writ of summons. Justice Pega, Ajabi and co. saw through the rules and said, hey, please. You are afraid of Article 146 proceedings. So essentially what you want to do is to use the writ action under Article 2 to basically achieve the same outcome. We will not permit you. And if you read the judgment of the Supreme Court in the Urban case, my Lord Justice Pega had this to say. He said, look, as lawyers, as the creme de la creme of the legal profession, we expect better from you. And that, listen, the reason for Article 146 and its in-camera proceedings is to preserve and protect the independence of the judiciary and not turn an Article 146 proceedings into a theater like it usually happens in the courtroom. Now, what essentially now removed Chief Justice is doing is that if she successfully triggers the jurisdiction of the judicial review jurisdiction of the High Court, essentially what she's doing is to put the Puaman Committee, which otherwise is supposed to be in camera, to now an open conversation. That is where the constitutional lawlessness is. Because now that she had filed, if you respond to it, you have to come and do a merit review of the work of the committee.
But you're essentially questioning the basis for her removal.
Exactly. And so the committee's work is supposed to be in camera. Now, immediately you put it out in the court. Court proceedings are not in camera proceedings.
To strengthen your argument, but the Supreme Court in the Derry case said after it's over, they should release it. No, it's broken.
No,
so
no, I'm coming. So the point that we all need to appreciate is that in the wisdom of the framers of the Constitution, they did not make the work of the committee under Article 146 a subject of judicial review. The judicial review powers envisaged either in CI 47 or the Constitution itself to the High Court does not include the workings of the Article 146 committee. And the policy rationale is to preserve the in-camera status of the work of the committee. Because you see, at this point, if she succeeds in her action in triggering the jurisdiction of the High Court, what it means is that the AG by law would have to file affidavit in opposition. And in that affidavit in opposition, deposed to the fact that the committee's work and whatever were all fair, it's So what it means is that you have to bring the works of the committee before the judge.
And in fact, there's been calls to the extent that the committee has finished and submitted the report.
Finality.
That report should be made public.
Yes, the Supreme Court itself says so. In the Derry case,
you see,
it says they are not against publication, and we are waiting for it. We must get those reports.
The danger,
Mahama, we must.
I know my senior brother Martin Kwebu. Martin, when it comes to issues about legal matters, if you don't put a chain around him, he can run, for want of better word, run very rogue. and
to help our democracy.
Please. And stretch the law to a position that if we are not careful, we may have to rewrite the Constitution. And Kwebu has the tendency of rewriting the Constitution, using advocacy. But that said, what we should not allow in this circumstance is to permit
we ensama horo timi ko so channel no so mam na wase wo yemre e wo ha da se ne so ba de ndia edumi ni ya yebasa ba wram ne ya somo kwan sonko so kra aha GH Politics Avenue.